that will provide industry perspectives on our topics today. My furthest right is Christian Genetski. He's the Senior Vice President and General Counsel for the Entertainment Software Association. To my right is Joe Gratz, who is a partner at the law firm of Durie, Tangri in San Francisco. Then we have Scott Martin, the Executive Vice President of Intellectual Property at Paramount Pictures. And finally, Jay Rosenthal, who is Senior Vice President and General Counsel of the National Music Publishers Association. And so each speaker will take about 10 minutes, more or less, and then we'll have a couple of questions within the panel and then open it up to everyone else. So Christian, if you want to start.
Good afternoon. I'm glad to be here and appreciate the opportunity. So I work for the Entertainment Software Association, which is the trade association that represents the video game industry. Most of the major U.S. video game publishers, a variety of size, of who those entities are in our industry. And I thought I'd start just, sort of frame how our industry comes at the copyright issue. I mean, there are a few sort of threshold points, one of which is we're an incredibly immature, in terms of number of years, industry. When you think about sort of the hallmarks of content creators, the video game industry really dates back to about the mid-'70s. So I'm older than the video game industry is. But from its inception, it is an entire industry built on the foundation of copyright. Both the devices that enable gameplay and, of course, the game content itself is grounded in copyright, trailing shortly after the 76 Act. Most of the works that people are familiar with were created. And I think it's a medium that combines both software code and art together to create interactive audiovisual works, with interactivity really being the hallmark of what makes video games different from other art forms. Unfortunately, for much of the industry's history, the principal fight it has been associated with has been one really more of a First Amendment battle and attempts to fight back government regulations of content. And I think it's a similar story to other industries represented on this panel and that we've heard about today, and others we haven't talked about as much, like comic books and things like that. There's sort of a cultural evolution that takes place when there's a new art form, where regulators and the culture sort of gets used to having it around and starts to view it differently. And I think with culminating in the Supreme Court case in 2011, which was Supreme Court sort of recognized that video games are on equal footing with other art forms. There's been an evolution in that respect, and we're now viewed a bit more equally among our brethren in the copyright community. For that entire same history, however, we've also kind of gone through the same ebbs and flows in trying to protect the value of the copyright that serves as the foundation for our industry, and certainly have experienced, I think it's a pretty similar sort of trajectory over time, whether, from the cartridge days, sort of I would say the equivalent of the video of the cassette tape in the music business, from the cartridge days to CDs, which are still a big portion of even the most current generation of video game consoles, to an explosion in purely online play, mobile devices, and sort of a great democratization of the industry that's taking place now. The key problems and the key attacks on the value of copyright in the video game industry have tended to focus around those who are trying to break down security measures or protections of those cartridges, discs, of online servers, either to make illegitimate copies of the game to get the games for free, or to cheat, sort of defined broadly, which can mean a number of things in the video game context, but devalue the integrity of the works for not only the publisher, but in many cases for the other players of games, particularly in collaborative and online games. The internet obviously been a tremendously complicating factor. Video games are distributed in digital format, so all the same problems that we've heard discussed today for others have impacted the video game industry also. I think What we've seen, though, over that evolution of time and the response to new technologies for our industry has been somewhat different from others. And part of that is because the video game industry has included pure game publishers, but also platforms from the beginning. And when those platforms were purely just a device that sat on your shelf in your home and was there for you and other people in the room to use, you would have distributor, publisher sorts of differences of opinion. But it's very different. What the internet unleashed is it transformed those devices. That they may still sit on a shelf in your living room, but they've got several wires running out the back of them, or they're hooked up to your wireless network, and they're connecting you to millions of other people around the world. So they're now online platforms. So our industry is really a combination of both content creators, really all of my members are content creators, but a number of them also view themselves as platforms and distributors of their own content and third-party content. And there's an increasing movement in our industry towards enabling user-generated contributions to works, to enable sharing of gameplay clips, for which our members would have copyrights, but they've put a share button on the most valuable real estate in the video game industry, which is the game controller. There's a button labeled share, which allows you to upload the video, including your commentary, when you've taken a friend down in Madden football or some other game. You can immediately upload that to Twitch, a third-party video service, or the console's own services. So there's kind of an evolution in thinking about how we do this thing, and I think sort of a broader approach to trying to buttress the overall value of the copyrighted works through a number of different methods, some of which are not sort of intuitively as protective as you might expect. That said, we are in my trade association are heavy users of the tools that are available to copyright owners to try to protect their works. We send millions of DMCA takedown notices. We avail ourselves of every search engine's own systems. We are preferred providers in all of those to take down works, and someone back in my office is working on that right now. Our members use technological protection measures in all kinds of different ways to try to protect their access to content. And I think now the biggest component for our industry, though, is to think about how they can use those technological tools to enable creative new ways to really compete with free. Because I think that we've reached the point in our industry where the conclusion is, let's offer a more compelling experience than a pirated or an infringing version can offer. And if we do that, consumers will choose the legitimate version. And there are methods available to the video game industry that aren't necessarily available to others that ease our ability to do that, like having purely online play that's with sort of a gatekeeper to access to where the content is held back on the game publisher servers. But it's also done through price point differentiation. I mean, the most explosive growth model for the video game industry now is free to play. And I know it sounds difficult to say, I should compete with free by also offering it for free. Seems like a hard model to monetize, but the way the free-to-play model works is that there is a free version of the game available for everybody, but for those who want to advance more quickly, acquire different, whether it's weapons or uniforms or whatever attribute in the game they want, they can pay for that. And the model's proved when you have 30 million people playing daily worldwide, and a lot of them are competitive and want to get ahead, they're willing to pay. And those who want to pay are monetizing the games for those who prefer to have the free light version. And a number of different models, things like online subscription models, Netflix for video games, a lot of publishers are experimenting with, making old back catalogs that there's been an argument the only way you can play a game, a nostalgia game from 15 years ago is to find a pirated version with an emulator online. Those are now being made available on the publisher's services at sort of low-cost entry points, the whole back catalog at a certain price. Takes TPMs to do that. So the last point I'd wrap up with, that's sort of the picture of our industry. What that means for us when we think about copyright law reform, there's really two areas that we're largely focused on. The DMCA, but less so the notice and takedown, and more Section 1201, the anti-circumvention prohibitions. Because the ability to gatekeep access to content and offer it sequentially is pivotal to the ability to try these new creative business models. So we think it's important that there not be an unwinding of that protection. And the second one is the strong licensing regimes. We believe that having a strong freedom of contract, transparent contracts between users and content creators and publishers enables consumers to get what they want at the price they want it, and they understand that there are certain restrictions that come with that, and they're willing to accept those. So sort of one-size-fits-all digital-first sale models, which some have called for, we are extremely wary will have an unintended benefit.
Great, thanks. Joe?
Thank you. Hi, my name is Joe Gratz. As Gene Mopsick said at dinner last night, we were all sitting around a table having a speaker's dinner. He said, I introduced myself, and he said, Joe, and I know Gene pretty well. I said, Joe, he's from the dark side. You should understand this. And this is, in some sense, in this room, perhaps true. I represent Google in the Google Book Search litigation. I represent Aereo in their litigation with broadcasters. I've represented defendants sued by big record companies and won. I basically come from the internet. But I've also represented individual artists. I represented Shepard Fairey early on in his case. Recently we represented a New York photographer as a plaintiff against groups that had used one of her photographs in an anti-gay political mailing in Colorado. Say again? Occasional lapses, says Gene. So I want to say I'm here to speak only for myself, not my clients, but I want to contribute what I can to the discussion. The conference, we're here today to talk about how copyright reform can work for creators and in particular professional individual creators. So I want to talk about some of the common ground between creator communities and in particular professional as opposed to amateur individual creator communities and technology communities. And I think there are a lot of things that we can agree on and can work together on. There are, I think, a lot of things that we aren't going to agree on, and some things that were discussed this morning that I think are not sort of moving things in the right direction. So I want to think about where there are places where there's friction in the system that is keeping money from flowing to individual professional creators, where technology may be able to be useful to free up that friction and cause that to flow. Before I talk about that, and specifically about perhaps some copyright reforms and pieces of the Copyright Act that we might all be able to agree on to move toward that goal, I want to talk briefly about a couple of the things, just three of the things that came up on the creator panels. And this is a bit of a potpourri of issues. The first thing that I'd like to talk about briefly is I don't think that fair use is the problem, and fair use is not what is preventing individual professional creators from realizing revenue streams. You hear Gene say that with the expansion of fair use, he's not sure there's a future for image copyright, but I don't think that's the case. Almost by definition, fair use doesn't interfere with the normal market and the normal exploitation of a work. That's why courts take that into account in determining whether a particular use is fair or not, whether it is a substitute for some existing revenue stream or whether it isn't. 3 Snippets, just to give one example, is no substitute for a novel or any other book that's in Google Books. Fair use limits copyright where prohibiting a particular use would stifle the activities that copyright is there to encourage. The creation of new things, and some of those new things being created are new works of art, are physical transformations of the original. Some of those things are different purposes and different meanings of the art without physical transformation of the into a different creative work. Changing just the audience or the medium isn't fair use, but changing the purpose or the message can be fair use. I heard it mentioned on an earlier panel that maybe the rule now is anything with a great social benefit is fair use. I don't think that's the rule, and I don't think that anything with a great social benefit by itself it justifies a finding of fair use. So I don't think that limiting fair use is the solution or any part of a solution to the issues that were raised and discussed on the artist panels this morning. When you make a real fair use, you aren't taking something away from the source material or the original creator, but instead making something new and a new contribution to the world. That's why I think that to the extent fair use has been discussed, limitations or changes to fair use are not the solution, and fair use is not the reason or the cause for the problems that are real, that have been identified both in the keynotes and in the artist panels. The second thing I want to talk about is the ways that the internet can provide real value for individual creators. We've heard about the ways that the move to digital works has presented challenges for copyright holders because copying is inherently easier and broader with digital works than it is with analog works. But technological change has created a lot of good things for individual creators as well. I'm not talking about iTunes here or Netflix necessarily. Those have generated significant revenue streams for large corporate copyright holders that, as we have heard, sometimes have trouble flowing to individuals. But I want to think about and point out some of the ways that technology has enabled individual creators to realize new and different models and revenue streams, at least in some areas, and start to think about ways that those might be expanded to other areas. One of the things that we can do is get people used to paying for things again. And that is fundamentally, I think, a problem that's come up on each of the panels, that people aren't used to paying $14 for a CD. They're used to going to Spotify, listening to an ad, and streaming whatever song they want. But I agree with Eddie that people want to pay individual creators. I don't think people necessarily want to pay large corporate copyright holders, even if, in fact, those are the payments that will ultimately trickle down to individual creators. People feel good about paying individual creators. And technology, I think, provides a way to lessen the transaction costs in a way that allows individual creators to realize those revenue streams more directly. I'm thinking about things here like Bandcamp.com. Has anyone here downloaded music on Bandcamp.com? I see a couple of nods. Good. This is perhaps the most direct possible, transparent possible music payment system. You are sending a PayPal payment directly to the artist's PayPal account and then downloading the music. And they can set a price and you can pay more. My understanding is, and this has been my experience with my own downloads, you frequently want to pay more than the minimum. This is not a replacement for major record labels. This is not a panacea for songwriters, right? Who for covers will still be getting the statutory rate, but it's, I think, a model for ways we can look at to maybe use technology to break down the barriers to getting individual professional creators paid. Artist share is another example of that in music, and I think, is there a way to do this for photographers? Is there a way to open up this kind of a more frictionless market for the licensing of photographs? And as we heard in Doug Wright and Lisa's comments, what can we do for areas that are not subject to sort of distribution of physical goods in their traditional forms? What can we do for theater? Is there a way to use technology in a way that's positive for individual artists in that area? We see some of this in small ways with the digital theater streaming product coming out of Britain, creating new revenue streams that may be able to supplement the existing revenue streams that, I guess, in the case of theater, may be particularly robust against piracy, in that you can't just break into the theater and you fundamentally need to buy a ticket. But are there ways that digital technology can supplement this? In my last minute here, let me talk about some of the legislative proposals and ways that they might be able to help both, I think, the technology community and the individual creator community. One thing we've heard about is registration. Having a good registry of all of the copyrighted works and who owns them is a great boon to licensing and may even lead us to an automated licensing future. We are a long way from that. You can't even tell who owns something today by looking at every record in the Copyright Office because recordation of transfers isn't mandatory. We should move toward a system where there's a digital record of who owns all of the works so that if one wants to license something, that can be as seamless as possible. And I agree with those who have said that having a small claims forum for smaller copyright disputes is, I think, very important to individual professional creators. There are a lot of claims, I think, that individual professional creators may have where the defendants in those cases, whether those defendants are individuals, small companies, or large companies, may well be interested in opting into that sort of cleaner, more efficient system to avoid the very high costs of federal litigation. So thanks very much.
Great. Thank you, Joe. And now Scott Martin.
I think one of the frustrations that I have with a lot of the public discussion of the new copyright proposals, copyright law proposals, is how divorced a lot of those discussions are from sort of basic realities of business. So what I wanted to do is talk for a minute about, just in the context of the film business, how things are changing in the digital era. And what I've done is condensed everything I grapple with all day long to 10 minutes. And in the film world, it all begins with a creative idea, and then we have production, we go into distribution, and then consumption by consumers. And each of those has morphed from analog to digital. And it's all just happened. So if you think of time, we lived in the analog world for 100 years since the beginning of sound recording and modern media. We've really only been in the digital era for maybe 15, 20 years at the most. So in the timeline, even of Paramount Pictures, which has celebrated its 100th anniversary 2 years ago, the digital era is really still just a moment in time. And what that means is, in the analog era, we were dealing with a mature market. Now we're dealing with a constantly evolving market. It was an efficient market. We understood it. It had efficiencies. Now there's this constant turmoil. In the analog era, there were relatively few innovations, and they sort of came at about 10-year intervals. Now it's almost seems like daily innovation. And what that meant was, because you had mature markets, you had efficient markets, you had a relatively slow pace of innovation, you had predictable risk. Today, for any big media company, the risk is almost unknowable. And so it also means we've moved from the analog era of doing reactive planning to having to do proactive planning, but trying to do proactive planning when you don't know what is coming next technologically or with consumer demand. So just thinking for a moment about production, which is the first step. The digital revolution's been fantastic. We now have dynamic cinematography. We can do continuous shooting. We can do immediate review and edit. So when you're on the set, you can actually see what you've shot, as opposed to the old days where you said, cut, print, it went off to the lab. Several days later, it came back and you realized you didn't get what you needed, but meanwhile you've struck the set, the actors have moved on. That's no longer a problem because you see on the set exactly what you've shot. You also have enhanced visual effects. And I mentioned shooting. If you think about the 35 millimeter era, we could only shoot for 10 minutes at a time. Then you have to stop and reload. The most you could get through a film canister was 10 minutes. We then went to digital cards. They gave you about 25 minutes. Now with digital drives, you can shoot 50 minutes without stopping. But the other piece of this is the cost has come way down. One of the major factors in a film budget used to be the footage, and that's why you always hear the old, cut, print. because you couldn't let the camera keep running because there was money running through the projector. Now, you never say cut because there's no storage cost. And one aspect of that we see is we used to shoot about 10 minutes for every minute of actual movie time. Today we're shooting 40 minutes. And it's not that the production shoot is any longer, it's that no one ever says cut. Or you shoot with 2 cameras at once because there's no incremental cost. If we think about distribution, the way we used to get our movies into movie theaters is we loaded up all the film canisters in a big, heavy metal box, handed them to FedEx. FedEx delivered them to every theater in the country, and one of these boxes for every screen in every theater. We no longer do digital distribution, 35 millimeter distribution. We have a film, I think it's opening this week, in Men, Women, and Children, for which there is no 35 millimeter print, which opens up a whole issue with the Copyright Office about what is the best available copy for the deposit copy. What we do now is we send out a hard drive. In some cases, we are now distributing by satellite directly to the theater. And the cost savings is enormous over having to print the film, ship the film, get those heavy canisters back by FedEx. It also means more flexibility. You no longer have to worry about the projectionist burning the print at the matinee because he's not paying attention to the projector and not having your print for the nighttime show. Or if a movie's an unexpected hit and they want to put it onto another screen, in the 35 millimeter era, you couldn't do that. Now you just give them one more key for the digital copy they have. So if you look at the timeline, in the 1930s, vinyl came along with music. About 30 years later, you had cassettes. Then about 10 years later, you had first the Betamax, then the VHS, then the CD, then the DVD, and then the Blu-ray. And each of these technologies, more or less over time, supplanted the previous. So at the height of the DVD era, in 2000, we were still servicing VHS, but it was really DVD. And that's one of the things that made the market efficient, is you only had to make one version of it. In the digital era, we have over 100 digital platforms that we license just in this country. And almost all of them have different requirements. They have different compression rates or technologies. They have different DRMs, different digital rights management. They may have different anti-piracy systems. So we're creating different versions for every one of these. So for a single film, we create 15 languages, 5 edits, 3 screen sizes, 3 frame rates. That's 675 versions of every film before you get to the platform requirements, where you're now making additional versions to accommodate what Netflix wants versus what iTunes might want. And you can imagine the impact just on our archive. One film generates 2,000 archival elements. We get about 76,000 new archival elements each year. We're already past 2 million archival elements. So just trying to keep track of the amount of product that's generated off one film is enormous. So when we get to the evolution of copyright policy, you think there have really been 4 major copyright laws: the 1909 Act, 76 Act, the Bono term extension in 98, and then the DMCA in 98. All of those were really before the digital era. The DMCA was at the dawn of the digital era. But we're dealing with laws that no one thought of all of the digital challenges. And so we see proposals like there was one pundit quoted in the Sunday New York Times 2 weeks ago who was arguing for the elimination of the exclusive right of copyright and saying instead we should just have revenue sharing. And basically what that boils down to is you legalize piracy and tax it. And that's a great utopian idea. But then you have to say, does it actually work with business, and particularly the business of film? And one thing that we constantly look at is the profitability timeline for film. So we start spending money 3 years before the theatrical release date. We acquire material, we hire a writer, hire a director, start building sets, hire actors, go into production. And by the day we get to the theatrical release date, we have spent minimum of 20 million, and in some cases with prints and advertising up to 300 million. And then we're trying to earn it back. in the old days, and when I say the old days, I mean maybe 2 years ago, you would hope to get back to that break even in a year. So 6 months of theatrical, 6 months of DVD. What we're seeing now is it is more a 3-year time frame before you begin to break even. And if you go to, in effect, a compulsory licensing system without exclusive rights, you're going to push that 3 years back, who knows, 5 years, 8 years, maybe never. And so when people are going to argue for that type of a system, you have to say, what's the cost? And the cost may be no more Transformers films. And maybe you're okay with that. But you at least have to be honest with the trade-offs that you're making. So it's our hope that as these discussions go along, that people reflect on some of the business realities that come along with the choices. Thanks.
Thank you very much. And Jay, we'll close off.
Okay. I just want good Transformer films. They're not getting very good anymore.
You want Megan Fox back?
Yeah, that's cool. Yeah. My name is Jay Rosenthal. I'm the General Counsel of the National Music Publishers Association. I want to thank June for asking me to appear here. First of all, these comments are my own. It is not representative of my employer. You'll understand why. My background is particularly significant to the discussion we're trying to have today because I've represented the interest of a lot of different types of creators in a lot of different ways. 3 in particular different ways. One is I've represented artists in public policy matters on Capitol Hill as general counsel and lobbyist to the Recording Artists Coalition, which was started and run by Don Henley and Sheryl Crow and a number of other top artists out in Hollywood and actually all over the country. And now as general counsel and lobbyist to the NMPA. I've also taught entertainment law for over 20 years at Georgetown and GW and Washington College of Law, and I write extensively on these topics. Finally, and really most importantly for today, is that I am direct legal counsel to many different types of artists, including recording artists, songwriters, producers, DJs, actors, dirty comedians, monument makers, and even professional wrestlers. From Salt and Pepper, one of my first clients, to Thievery Corporation, which if you are a cool law student, you would know who Thievery Corporation is, perhaps, to the genius sculptor who created the Einstein Memorial and the Kennedy head at the Kennedy Center, to the former bouncer who wrestled for Vince McMahon for many years and recently starred as Drax the Destroyer in Guardians of the Galaxy. And if you haven't seen that movie, please go to see it because we are really close to that last box office bonus. You know what I'm talking about, aren't you? Yes. That's what we're looking for. So Drax, you want to see Drax? Okay, what are we looking at today? What are we trying to get to? I think that what I'd like to talk about is there such a thing as a unified theory of copyright when we start really figuring and looking at these particular issues? And I think you have to start with the basic question of what is copyright and what are the two varying different approaches to copyright. Is copyright an economic theory, as many copyright minimalists really contend? Perhaps, Joe, you believe this in a certain sense. Or is it a property interest? And perhaps even a human right. And this matters, especially in the public policy context, because if you believe it's an economic theory, starting from some point of equibalence between the interest of the authors and the interest of the users of copyright, like Google and other online services, then you believe it may be justified to impose compulsory licenses, or a broad fair use regime, or shorter copyright terms, or a DMCA that places the burden of policing the internet on copyright owners instead of copyright users, and on and on. But if you believe, as I do, that the philosophical and legal foundation of copyright must start as a strong property interest, and perhaps even a human right, with waivers and exemptions that are appropriate, but only if they justify a limitation of the property interest of the author, then you would strongly oppose compulsory licenses, which impinges upon the right to say no. as well as adoption of a very narrow fair use exception, adoption of strong statutory damages, a longer copyright term, and a DMCA that places the responsibility to police the internet on the copyright user instead of the copyright owner, and on and on. My position is that we should always default back to the question that, is this exception to copyright justified in light of the property interest of the author that would be abridged or limited? I believe this approach is constitutionally, legally, and historically supportable. The Founding Fathers supported this view. The favorite philosophers of the Founding Fathers supported this view, and I think that the majority, if not the vast majority, of the entire creative community supports this view. And let me digress for a second to the Founding Fathers, because now I'm dealing with philosophy. I think one thing that I've heard many times when we debate these matters is that, oh, when they passed the constitutional clause, it was an economic theory, and that there really wasn't a property interest. And I totally reject that. In all the copyright academics sometimes are just the worst historians of all. It is hard to imagine anybody who views the evidence of how the constitutional clause came into being can come to that conclusion. These guys were about natural rights. They were about inherent rights. They believed that there was a property interest. John Adams, who wrote the Massachusetts copyright statute, stated in the preamble specifically that these are inherent natural rights. And really, in a historical context, these guys were looking at creating a national culture in competition with that of Europe. They weren't thinking user-generated content in YouTube or Justin Bieber even. They were thinking, we need a Bach over here and a Monteverdi and a Charles Dickens. This is what they were thinking about. So this idea that, in fact, our system is based upon an economic theory, I just believe is totally wrong. And this is why, on a certain level, the efforts of the Copyright Office and the USPTO are so important and vital. The copyright reform exercise we're going through in Washington, which is somewhat the search for the next great copyright act, allows us to re-examine the justification of certain aspects of our copyright system, especially those parts that limit the property interest of the author. And now I'd like to talk about just a specific example. And it was brought up this morning a little bit. And that specific example is the study from the Copyright Office on music licensing. We are in a spirited debate, albeit caused mainly by me and my organization, about the propriety and legal justification for the Section 115 mechanical compulsory license for musical works. We are calling for the elimination of the compulsory license. We believe that the rates set by the government greatly diminish the author's property rights. I mean, I think Rick talked this morning about, how can you want to ignore the fact that the compulsory rate started at 2 cents in 1909, it's 9.1 cents today, and could be pushed down in a future CRB proceeding. With a standard inflation index, that compulsory rate should be 50 cents or more, and we are sitting at 9.1 cents. Yet, there are many in favor of the compulsory because it provides efficiency, and yes, it does. And thus they rationalize the devaluing of the songwriter's property. Put in another way, they accept the wrong-headed notion that a songwriter is fine with getting paid less than fair market value for their property so long as it's done in an efficient way. So you pay a dime on the dollar as long as you're getting it every month, everybody's happy. And in fact, some are calling for an expansion of the scope of the compulsory license. We believe, my organization, songwriters, music publishers, that the free market will not only bring fair market value, but also efficiency. And thus there's a serious call for the repeal of this compulsory license. And this is the kind of debate that we just continue to have and we must have. And the question, though, on the ground is, are we in a crisis of songwriters? And the answer is absolutely yes. Certainly the songwriters who appeared this morning can attest to this. 20 years ago in Nashville, there used to be thousands of standalone songwriters. Today, possibly a couple hundred. This is a cultural catastrophe on any level. It seems the more government gets involved and the more we limit the property interest of the songwriter, the more we harm them. And as a general proposition, if we want to make sure that professional songwriters in the U.S. continue to write the greatest songs in the world, we must allow songwriters and music publishers, and all authors for that matter, the right to say no. And we must treat their property interests with the same respect we give to other forms of property. We have got to stop treating authors as second-class citizens in this country. It's just got to happen. If we acknowledge the full property interest in a great song, 10 to 1, the professional songwriter will write another great song. If we treat the property interest, the copyright in that song as something less than a strong property interest, 10 to 1, that songwriter will not write another great song, but most likely, and this is based on my experience working for authors every second of my professional career, they'll go back to working at McDonald's, and they're not going to continue to write songs. And I think that's what we're facing today, and that's, as law students, this is what you're facing as, what side of this fence are you going to end up on? Fighting for the rights of songwriters and copyright owners so that they can continue to write quality, great, professional work, or on the side where we have user-generated content and we get to see that video with the cat falling into the cake over the Jay-Z track over and over again on YouTube. Thank you.
Well, thank you very much to all the panelists. I have one question before opening up to the rest of the audience, which goes off a comment that you made, Joe, which is that you pointed out there's a potential harmony of interest between individual creators and technology firms. And to what extent do you see that harmony in your respective sectors? And to what extent do you see areas of conflict of interest among or between individual creators, the creator community, and technology firms or some of the larger firms?
I'll go first since my answer will probably be the shortest. I mean, I don't, my organization represents companies, game publishers, there are hundreds of thousands of talented individuals who work together collaboratively to make our works, of course. But I think for the game industry is a little bit uniquely situated in the identification between consumer, which we call a gamer, and the publisher. So we've heard a lot today about this sort of disconnect between the big corporations and the individual artists, and maybe consumers want to pay the artist, but they don't want to pay the publisher. Unlike when you go to a film, you don't necessarily think about whether it's a 20th Century Fox or a Paramount production. You tend to think of that Richard Masser's in the film, and that's why you're excited to see it. And music you very closely identify with the artist, not the label. And games, that gamers know who the companies are that publish their games. Those brands are tied up with the brands of the game. And so I think it's a bit of a different experience for us, and it enables the publishers themselves to dabble in technological innovations and push content to consumers at a bunch of different ways and sort of see what works, because gamers are enthusiastic about the publishers themselves. They're also extremely vocal about practices they don't like. If there's an overuse of DRM, game publishers hear about it quickly, and if it's going to devalue their copyrighted work, they'll roll it back, and there are a number of instances for that. So I think it works itself out a bit organically. So I guess, yes, I think for our industry, we have seen that kind of synergy happen, but I think in fairness, we're a bit uniquely positioned. It's not necessarily transferable to others.
So I think this is a little bit of a amorphous question with respect to the entire internet. But I think with respect to the entire internet, there are lots of places where the internet, or even more narrowly the commercial internet, the big internet companies, are doing things that help individual creators directly or indirectly. I mean, just as one example, Google Books sells tons of books. The empirical proof of this is 45,000 plus publishers choose by their own choice to put books in Google Books so that people can find them, sample them, and then buy them. Where is there a conflict? I think that it is difficult for an individual creator to watch, and I sympathize with this and I see it, that it's difficult for an individual creator to watch their creation be profited from by someone else, regardless of what the law says and regardless of what the economically efficient copyright system is, and by the way, yes, copyright is an economically based doctrine, not a natural rights doctrine in the United States. That's what we're doing here. And it is hard to watch. And I recognize that, and that is a place where there is perhaps an irreconcilable, but certainly a conflict.
I think part of the challenge for us is, we love the digital era. We love all this innovation. It's enabling us to make movies in ways we couldn't make them before over time. I think it's going to make enormous cost savings, but it's also making piracy easier. Some of our distribution partners are also some of our biggest pirates. And so there's a lot of challenge in getting people to pay for content they can get for free. And we're trying to make it available in all different models. There are three major models. One is the all-you-can-eat subscription model, which is Netflix. You pay a monthly fee, you watch everything. Another is a download to own. So on iTunes, for a certain price point, you can download the movie and have it forever. And then another is a rental price, which iTunes offers, where you get to watch it for 24 hours. And all of those differences are made possible by DRM. So at the same time that there are some organizations or some pundits that rail against any form of DRM as being anti-consumer, our view is that's fundamental to consumer choice, because that's what gives you those different price options. When I arrive at LaGuardia Airport and want to get into Midtown, I can buy a car, I can rent a car, I can take a taxi. They're all priced appropriately. And if my only option were to buy a car to get into Columbia from LaGuardia, I wouldn't be here now. So I think it's both a challenge. Hopefully, I think what we're beginning to see is that some of the people who in the past have been our greatest problems are starting to see the value of content, the value to their own business model, their own self-interest. So hopefully over time this is going to change and improve.
Right now, the position of the songwriters and the tech companies and the services is not in a good place at all. I think politically it's getting worse and worse. I think that what many of the companies are doing are stoking, the flames and the fires of everybody getting radicalized. I think if it wasn't for a lot of the positions that these companies took, guys like David Lowery, David might be working on his 12th album right now instead of coming to Washington and running around and talking about these things. And I also think that let's not forget about when you say that, economic theory is what we're dealing with here. The two most important words in the constitutional clause are Congress shall. That means that this is a political struggle that we are in. And don't think that whatever is happening today will be in the future and that we should rely on this. In Europe, there is a much more property-centric view of copyright than we have over here. And it is guys like David and Rick and these other guys who are radicalized and continue to get out there and fight that might change this. And I kind of analogize this to the political problem of voting rights. Here we have all of these, these state governments trying to restrict voting rights across the country. And what is it doing? It's just getting people pissed off. And they're going to go out and they're going to probably vote even more than if they ever raised it. And yes, I am analogizing the Tea Party to the tech companies. Yeah, I am. I am. So my point is the political struggle's on. This is not over.
All right, let's open it up to the rest of the audience. Yes.
And I want to hear it. But let me respond to I think the 2 points that have come up so far, and I think those fall into two related buckets. The first is moral rights, right? And what is or what should be an artist's right to the integrity of their work, to the avoidance of reputational harm to them from the mutilation of the work, the misuse of the work, the use of the work in ways that they would never intend, that harms them as an artist. And the answer is United States copyright law, other than Section 106A, does nothing about this and shouldn't. This is not my view. This is the Supreme Court's view. The Supreme Court says the sole interest of the United States and the primary object in conferring copyright rights lie in the general benefits derived by the public from the labors of authors, not, as in Durer's case and as in the tradition that flows from that in Europe, to provide a right of paternity to the author. That is not what American copyright law does. And we can argue, I think, about whether it should or whether it should to a greater extent, whether VARA should be expanded and so on. But I strongly think that there isn't a basis for that in the current law. And in my view, I think there probably shouldn't be. The second piece you talked about is fair use. And I agree with you that a change of context does not mean that a use is transformative. If you take a logo for one company and use it as a logo for another company where it has a different meaning, that is not a change in purpose, and that's not transformative. But there are some changes in purpose, that changes in meaning, that are transformative. Now, the Seltzer v. Green Day case, you noted that where there was a piece of street art that was used in a set design with different images laid on top of it. I think even taking out the laying images on top of it piece, that I think relates more to the moral rights piece, was it fair use to use that in the set design? I agree with you. That is at very least a very close case, I think. Whether using it on a wall on a stage was a different purpose than using it on a wall on a street. But I think that the doctrine itself, that using something for a different purpose, as in another theater case involving the Jersey Boys and the use of a very brief clip from a television show, I think that is a different purpose, and the doctrine itself is right, even if particular applications, like maybe in the Green Day case, are very, very close ones.
So I guess this is for Jay, but maybe anyone else. First of all, you used greatest songs in the world and Justin Bieber in the same speech.
Yeah, I did. I'm sorry.
Second of all,
I apologize.
would it make sense to try to reestablish some sort of balance by saying that a musical work and a sound recording should have more or less the same copyright treatment, which would mean in the digital area, full exclusive rights, and I guess no antitrust, unless the antitrust department thinks that having 3 PROs and having 3 record companies is the same. But then the price to pay for that is that the sound recording would have to be paid for non-digital broadcasts. So would that be a better situation to have equality between?
Yeah, well, you've just given a great Washington example of the trade-off. Yeah, there's the publishers have always supported the idea of a terrestrial radio right. Maybe they've been a little bit skittish about it because, the whole idea of the pie, it's like, we've got all our public performance, and if another public performance is out there, maybe the pie will, kind of decrease as opposed to expand. I hope that it would expand. But no, there's no doubt that that's a form of a trade-off. And your point about just analogizing, okay, here are the songwriters and the music publishers in a much less property interest mode than the sound recording side of it is absolutely true. And yes, I think that would be a great trade-off to have, to give a terrestrial right, and in exchange to get rid of the compulsory, and to allow possibly putting aside the antitrust concerns, which are real, maybe overblown, but real, depending upon who you're talking to, I think is a fair trade. And I think that many would consider that to be a great place to start talking about a final kind of unified way to fix the problem. I would be in favor of that conversation, for sure.
The natural rights that our founding fathers were interested in was actually primarily the public domain, that the rights to the copyright and to the patent holders, the inventors and the writers, to create an American society, was that the copyright and the patent was the bait, and that the real time when the work that they do would really get used was when it was in the public domain and was able to be used by the public. The founding fathers, what they were looking at was the back catalog, Greek and Roman, the Bible, Monteverdi. Right now, we're looking at the back catalog of Mark Twain, Beethoven, Mozart, that we can make use of because it's in the public domain. In this country, having a copyright period of 200 years, that recordings from the 1890s are still going to be in copyright until the year 2067, is ludicrous and is unconstitutional. And Lawrence Lessig apologized for having blown that case.
Yes, he did blow that case from his standpoint. I disagree with that position. I think that there are possibly many reasons why the limited terms, and I think that's what you're referring to when you say the public domain, the insertion of limited terms in the constitutional clause was placed into that. We are talking about founding fathers who, at the same time that they were creating a federal system, totally believed in state systems. And there is nothing to believe that they didn't believe, some of them at least, that once that initial term was over, that states' rights would not become paramount. Preemption of copyright occurred much later than the founding fathers. And I think that that's where we got off track, and I think that that's where we have to look at to try to get back on track. So I think we have a disagreement, a legitimate one. I know your point of view, I know the history on that, but I think I just disagree with you on the natural rights of this. Certainly the folks who wrote the state copyright laws spoke of natural rights in a much stronger way than you just did. So we just have a difference of opinion. We're just going to have to, kind of accept that.
There's a question in the back there.
Thank you. Is this on? I'd like to come at this from a Hollywood perspective. I was thrilled to hear Scott talk about print. So the joke now is the biggest cost always used to be P&A. It was prints and advertising. We've eliminated through digital the cost essentially of prints. But the piece that Joe mentioned about the internet is really interesting based on what Richard was saying earlier. Advertising is now socially driven. The A is not going away, it's just being transferred. Those costs have been switched from the studios in large part to the end user. So earlier we were mentioning the analogy with not punishing the user but the pusher. I would be really curious to hear what the panel thinks about having the Copyright Office help people like us who are creating content get it out in a way that we can meta tag it and find out how it's being sort of sent into the world and get paid for it, but still have people who are using it and love our cultural content feel free about sharing it. That's a huge part of what we do in this country. We share data. I mean, Jan Hooks passed away last night, and if you wanted to find anything about her work on Saturday Night Live, the only place to go was YouTube. And I don't know if it's because, NBC didn't want to release her work, or SNL did. I mean, there are a lot of people in the chain, but fans want to connect with their actors that they love and with stories that they care about. And it's the digital piece that's the broken part for us right now. Thanks.
I'd just like to just touch base on the Copyright Office. We have a representative from the Copyright Office here, and he'll talk about this. And Maria has constantly, in the past year or so, maybe even more, pushed for an expanded role of the Copyright Office, and I think that would be a wonderful thing to have happen. My only fear is we live in the age of sequestration. I'm not sure they have enough money to do what they're supposed to do right now. I wish they did. I wish it was. I used to work at the Copyright Office. That was my first job out of law school, and I wish we had more money back then. I started when they started cutting the first employees, and it's just been more and more ever since. So if we have legislators who are believing in the Copyright Office and will fund it to do that, I'm all with you, and I think we should go down that road.
And I also think when we talk about all these different proposed changes, the most important thing to keep in mind is you can't have one size fits all. So whatever works best for a Hollywood studio isn't necessarily the best for an independent filmmaker or a documentary filmmaker. We are trying to get to a mass market. A documentary filmmaker may not. And so you need to be looking at things like meta tag, whether there's a role in the Copyright Office. We hugely value the recordation system of the Copyright Office. We think it's one of the reasons that the film industry is so successful in the US, because we can track down rights. We can find things, perhaps not with graphic artists or photographers, with small works, but the kind of works we deal in, whether it's books or underlying works, we can find those. And everything we can do to incentivize more people to record, to make the system more online searchable, I think is better for everyone. And if there's a role for the Copyright Office in meta tagging or other functionality, that's great. Where it all runs full speed into a brick wall is money. Yeah. The Copyright Office can't even digitize or fully digitize the 1976 records. To expect some of these things to happen in the near term. And maybe there are other ways to do it, like giving the Copyright Office more authority to be flexible in the way it sets fees, how much it keeps of its fees. I think there are ways to do it other than money from Congress. It may be more authority for Congress, for the Copyright Office to be entrepreneurial and creative.
Yeah, I think that we should triple the registration rate for movies and cut in half the registration rate for music.
Yeah.
Is that good?
And I will say,
that might be the.
we're
No,
fine
I'm just
with
kidding,
that.
obviously.
I think one of the problems the Copyright Office struggles with is one size fits all
it's true.
registration fees.
That is true.
And the registration fee for a photographic work by an individual photographer should not necessarily be the same as the registration fee for transformers.
Yeah.
But to sell that, you have to couple it with, you're going to get better service, you're going to get more digitization, you're going to get something out of the increased fee.
Yes, and I think the Copyright Office does charge extras for expedited, right? And so these guys register always late, so they need, they always pay extra anyway.
In terms of, I think, figuring out what registry would be needed and what the functions are, there's a small body of literature from some of these copyright academics that we heard all of, maybe we take it with a grain of salt, but thinking through what the system would look like. Much of it came out about 10 years ago. This was, the term that they used was alternative compensation systems, and it was all related to whether we could figure out a way to create a revenue model for peer-to-peer sharing. And so there's a paper that I wrote and published in law school on this 10 years ago to check out. And it turns out it's probably still a utopian dream 10 years later.
We also think Creative Commons licensing is fantastic. It just has to be optional and not imposed.
Christian, did you have a closing thought? Well, with apologies to everyone who still has a question and didn't get a chance to ask it, we are a little bit over time, and so we'll need to close. But please join me in giving a round of applause to the panel. Very nice. That was great, man. Before everyone